Good afternoon, and thank you all for joining, and to TL4 for bringing this webinar to you. I'm Claire van der Zandt. I'm Director of Strategic Partnerships at ShieldPay and your host for the day. And I'll hand over briefly to our panelists to introduce themselves. Rosie, over to you first.
Hi, good afternoon, everyone. I'm Rosie Murray. I am an Assistant Portfolio Manager at Orchard Global, based here in London.
Thank you. And over to Claire.
Thank you, Claire. I'm Claire Duxbury. I'm founder and CEO of Case Pilots. We're a claims administrator focusing on both opt-in and opt-out multi-party actions.
Thank you. And last but not least, Andrew.
Hi, everybody. I'm Andrew Hill. I'm a partner here at Fox Williams, and I head up our securities litigation team.
Brilliant. Thank you. If you have any questions as we're going through, please use the Q&A function. I'll try and monitor that, and we'll bring up questions as they come in. To give you a bit of a summary of today, we actually first started planning this webinar at the start of the year, and it's taken us a little while. We have got there, but when we were looking at what does 2024 have in store for litigation, seeing as we're halfway through April, we decided to tackle a slightly different topic. And I thought it would be really interesting to bring these experts together to talk about the very nice to have challenge in the unprecedented growth we're seeing in the UK litigation market. So in a market that's experiencing a number of multiples of growth across the number of cases, the claimant cohorts and funding that's supporting the cases, what are the key changes that law firms, administrators and funders should be thinking about to drive scale into our operations and delivery? And much more broadly, I've had a quick squiz down the invite list, and we've got, people from all over the litigation community, whether that's experts, witnesses, e-discovery. So, how are we all shaping up to be ready for unprecedented scale? I also know we're coming at you from the competition community, but I think this topic has relevance across all of the collective redress schemes. So whether that's class action, group litigation orders, mass tort, any of the commercial litigations under the CPS 19.8 or FISMA 90A, anything that has that collective sense to it, I think, you can probably take away something useful from today. I hope so anyway. So whether it's precisely 10x isn't really the point. The point is we're seeing massive growth, and I thought it would be helpful to just start with a few examples of what I mean. So if we look back at the VW emissions that settled in 2021, that was 193 million to 91,000 claimants in the UK. If we now look at PAN-NOx, which is the 14 manufacturers who are in the emissions group litigation space now, there's over 1.25 million claimants already registered and reported to be billions in settlement values. So, we are starting to see the birth of these mega settlements. If you look at the class action space specifically, CMS does a fantastic report every year. And if you compare 22 and 23, we had 110 new cases in 22 filed, 171 million claimants actively involved in cases. Zoom forward to 23, we had 121 new claims filed that year and 340 million claimants actively involved in cases. And to put that into context, that's every person in the UK actively involved in 5 cases. It's a lot of people. And of course, large cases demand larger investments. And whilst the overall litigation funding market has contracted slightly over the last couple of years, new models of engagement are emerging to be ready to tackle the mega settlements that are coming over the horizon. So that's where we'll focus in on today. So in an ecosystem where we're all about 10x operations, are we ready? First question, what developments have we already put in place to scale operations? And Claire, I'm going to come to you first. So as a champion of technology-led solutions for class and group actions, what are the practices that simply don't stand up to managing claimants and cases that are exponentially growing in size?
Sure. Thank you, Claire. I could probably spend a whole hour talking about the practices that are not may not be ready for this onslaught of high volume claims. But let me home in on what I think is one particular area that gives rise to risk when we're talking about these big multi-party actions, and that's the use of spreadsheets. It sounds very basic, but we see it time and time and time again with some of our clients and cases we work on. And I think the natural tendency when you first start building a book, if you like, of claimants is to start putting them on a spreadsheet. That seems like the natural place to go. But very quickly, the spreadsheet becomes this enormous, unmanageable machine, if you like. And, Excel is just not built for that purpose. You can't put controls into cells. You have version control issues if more than one person wants to work on it. There's no audit trail. There's so many things that you need to be able to do for the life cycle of these cases to manage them efficiently that you just can't do in Excel. So I think, my number one tip, if you like, about practices, and we're already seeing this, we're already seeing many law firms and those involved in multi-party actions going down this route. But certainly, one of my number one tips would be use dedicated software that is designed with the twists and turns of these cases in mind, and which can afford you all of the things that a spreadsheet can't. You end up with what's known, we like to call the central source of truth, but there's just one data set. You've not got data across multiple locations on multiple spreadsheets, every stakeholder, and that would be a combination of your claimants, the legal team, perhaps your funders, perhaps third-party experts. Everyone is logging in to work on and review that same central source of truth, if you like, that same set of data in real time, and that really has to be one practice that is absolutely essential for gearing up for this 10 times or whatever times growth that it is that we're seeing. And then I think once you start doing that, once you're using a dedicated sort of multi-party case management system, not only will you be afforded some of the benefits that come with that around sort of security and data protection as well, but also some of the other practices that are long-standing internal law firm practices organically start to be redesigned, if you like, through use of the software. So instead of having a bank of paralegals who are all trying to manage claimant communications via their own email boxes, you can have a centralized inbox that's for that project, where your team can log in and just take the next one in the queue and answer it, and someone else can see that answer if that person was to come back into the inbox. And then, doing a bit of crystal gazing here, but once we start getting more and more of these settlements through by using, fingers crossed, once by using this kind of software, you then benefit from integrated payment solutions like I know we have with you guys at Shield Pay, and you don't have to then rely on your law firms, don't have to rely on their internal accounting teams' practices to try and shoehorn a mass distribution program through that as well. So a number of practices there, but the underlying message is they can all be managed within the right technology, using the right sort of deployment of technology.
Absolutely. The poor old spreadsheet gets a bit of a bad rep, but it really just shouldn't be used anymore.
No, I mean, Microsoft Excel Microsoft always say it can handle up to 1 million rows, but that there's always limitations around system and network resources, etc. And time and time again, as I'm sure we've all seen, an Excel spreadsheet will crash in the middle of quite an important update, and that can be a very painful situation.
Yeah. And 1 million is just not going to cut it, is it, these days, when we're
No.
talking about the sizes of things like MasterCard and
Exactly.
all of the rest of it. So thank you. Andrew, so I know commercial and securities cases are often slightly smaller than the millions that we're talking about in the competition space, but there is still considerable growth coming in retail securities and institutional investor cases. How is Fox Williams preparing for larger, more complex cases?
Well, I guess the short answer is we're trying to move away from spreadsheets. But I mean, the honest truth of it is we're still relying on spreadsheets, and emails. And so we, as both of you and Rosie too know from this panel, we are looking at trying, in practical terms, to move ourselves forward into the 21st century so that we have, a tech solution that's appropriate for the whole life cycle of these, my particular type of cases, which are shareholder actions and which are opt-in. And I'm hoping that we can move to that this calendar year because, at the moment we're book building 2 shareholder cases in the old-fashioned way, and we've never done 2 at once before. We've done them sequentially. Now we're doing 2 at once, and it is really challenging, to manage the communications with claimants, potential claimants, funders, intermediaries, even before you get to the defendant, just to get these cases set up and established. So, it's sort of front of mind for me to try to move us in that direction, because I'm a big believer in the benefit of it, and even if it's in shareholder cases when we haven't seen the hundreds of thousands or tens of thousands of claimants joining, but I think that's partly, that's a problem because we haven't had the mechanisms or the strategies in place to allow that to happen. So just to give a bit of background in terms of the cases that we've done as a team here at Fox Williams, we've had maybe 200, 230 claimants in some of our groups. One of them at the moment, we have about 70. So they sort of range in size. But even at 70, that's a lot of clients in a multi-party action. Most of the time, they're institutional investors. So there may be multiple stakeholders within the institution that we need to report to. So even if it's 70 or 200, it's still a big number. And so the group sizes can change, but I think the organizational and the project management aspects, are very similar. And I think the point is, because of the lack of the structure or we haven't embraced the tech solutions yet. As Claire, as you said, I think there has been a gap so far, or there's been a missing piece in the market, which is the retail investors. So most of our cases focus on institutional investors, and so because they're institutions, we need to speak to fewer of them, to sign up fewer of them, to get our damages or potential damages booked to a certain size to make the case commercially viable. But if we had a tech solution that would enable us to manage, acting for 10,000 investors in RBS or Tesco or some of the cases that have been filed in recent years, that would enable us to do that, and so that's what I want us to move towards, or the industry and the sector to move towards, because there's no reason why retail investors should be left out of compensation if it's owing, and it shouldn't just be institutional investors that are taking advantage of the provisions of the Financial Services Markets Act.
Really, really interesting. And, we talked a little bit when we were prepping for this about actually, wouldn't it be great if some of the mechanisms from the collective redress, mass redress schemes were available in the commercial space? Maybe it is that really broad look at what is the best way to handle mass claims, both from a legal perspective and a process, but also in terms of the technology and the processes and the, dare I say it without a shameless plug, suppliers who can really help you on that journey. I know we've got a few litigation suppliers in the chat, in the webinar today, so I'm sure they'll be nodding along with us. Rosie, bigger cases will naturally mean bigger funding requirements. What does that mean in practice for funders, both from the size of the investments, but also the administration of larger investor pools and funds?
Thanks, Claire. Well, yes, it's certainly right that we're seeing an increase in budget size, particularly in the CAT, where it's not unusual to see budgets of 20 million plus. Opt-in group claims in the High Court seeking to reach bigger classes are also carrying significant book build expenses alongside heavy budgets for running of the claim. And whilst it is encouraging that there is funder appetite to fund those bigger deals, We're having to find increasingly creative ways of doing so. Concentration risk with these bigger budgets is a challenge that the funding market is facing. That risk will have different implications depending on the funder in question, but may cover jurisdiction, forum, claim type, and defendant profile. And as many of you will know, a number of the high-profile cases currently in the CAT have large tech defendants, for example, such as Apple, Google, and Amazon. And these cases are also the ones which seem to be attracting the biggest budgets. So it's therefore not surprising that concentration risk is becoming an issue for funders. One way to approach this issue is to look to co-fund opportunities, whether that is having one main funder and then one or two funders sub-participating behind it, or where you have a syndicate of funders behind a claim. Both arrangements are commonly being seen across the market, and given the size of budgets we are seeing, is something that will, in my view, only increase. There is an argument from some that co-funding adds a layer of unnecessary complication in terms of case monitoring and reporting. I don't personally think that is the case, and it's certainly not something that we at Orchard have experienced. There's a diversity of participants in the litigation funding market, and that means that whilst not everyone will be aligned with your process and preferred approach, whether that be the level of detail of case reporting that you require once a deal is underway, or someone with whom you share a similar risk appetite, there is likely to be someone who is. And we certainly at Orchard have a number of very successful co-funding relationships, and it appears to be the way that the market is responding to these bigger deal sizes. The alternative to this approach is for a funder to take the full risk up front and to look to sell on a portion of their commitment once the deal is underway. This is much more straightforward for a collective action in the High Court, but could be more complex in the CAT due to the continuing gatekeeper role that the CAT has and the potential argument that it should be alerted to any change in the funder makeup at any level. The alternative argument to this is that if there is no change to the funding at the PCR level, the CAT should not concern itself. But it would certainly be a question of judgment in each case, and I suspect at this stage most funders would shy away from potentially upsetting the apple cart in this way. We are also increasingly seeing insurance products coming into play in the market. Products such as capital protection insurance allow funders to offset their concentration risk concerns to enable them to access bigger deals. And obviously there's a cost to this, and it is more attractive generally to obtain terms across a portfolio of cases as opposed to a single case. But if it enables a funder access to a bigger deal, then it is, in the right circumstances, a cost worth paying. There appears to be a wealth of insurer appetite and increasing capacity for this type of cover. So in my view, it's certainly going to be something we're going to see more of as the market continues to grow. The other issue here, which is both an issue for how we price investments as well as the funds for which they may be suitable, is that larger investments will mean higher potential damages and may not always, but I suspect generally mean greater duration risk, in that they may lead to attritional, drawn-out litigation purely because even if the defendants recognise they're carrying a real risk, it may suit them to delay the resolution of the case for as long as possible. And the same considerations generally do not apply in smaller budget cases. So that's just something that we're very live to. And in terms of accessing the capital in order to meet the higher budgetary demands, you're perfectly right, Claire. And litigation funding, as well as many other asset classes, have been in slightly challenging fundraising circumstances of late, with a reportedly slightly lower level of capital entering the market last year. But that said, investor interest remains high. There continues to be new entrants into the market, and demand for the product certainly continues to be growing.
That's amazing, thank you. And I kind of automatically want to dive into a load of questions, but they might actually come up in the next set of questions. So I'll hang fire. But there was one particular one around, co-funding and whether that adds complexity. And questions from the audience if you're experiencing this or you think it's absolutely not complex at all. But as more and more cases come and we've got more and more co-funding or syndicated funding in structures in different various levels of maturation, and as you say, you've got the duration risk on top of all of that, which is it's ever increasing in terms of the time it takes to get to trial and settlement. Does that in itself create the complexity in the coming years? But maybe hold that thought and we'll come to it in the next step. Thank you. So that's a helpful look at the things that we were already thinking about or have put in place or are available to support scale in the litigation market. But what are the challenges that we still need to lean into? Claire, I'm going to come back to you. Part of the rich challenge of building technology is the pace of change. What are you prioritising on the roadmap for case pilots this year in anticipation of that continued growth and scale in the sector?
You're certainly right that technology doesn't sit still. So being a tech-first business, that keeps us on our toes. I mean, I guess I consider myself lucky because I have an in-house development team who it's just in their DNA to keep an eye on tech. It's what they enjoy doing. So I like to feel that we're constantly ahead of the curve, and we do know what's happening in the tech world and what's on the horizon, and it constantly reviewing how those developments in the tech industry can be utilized in the context of how we use tech to benefit us and our clients in what we're trying to achieve. I guess I couldn't talk towards this subject unless I mentioned AI, and I know that one should approach the topic of AI with some consideration, especially within the legal industry. And I appreciate, there is some reservation around to what extent you adopt and implement AI. But I think, if you look at for instance, the mass claims world, we've been using AI in the context of sort of interactive voice recognition, and those kind of support tools around mass claims for some time anyway. And really what we're looking at now is just an extension of that. So for us at Case Pilots, what's on the roadmap for this year, certainly analysing the effectiveness and robustness and accuracy of certain AI tools and how we can bring them into what we offer our clients. As a Microsoft partner ourselves, we're able to benefit from the use of deploying Microsoft's own AI tools that they've developed. So I think that we're in pretty safe hands there. They've actually called their AI tool Copilot. I like to think they fashioned that on our business, but I suspect not. But I'll believe that for a short time. So certainly AI, how can we use that? Because if you use AI in a clever way and a sophisticated way in a mass claims environment, you can have loads of automation happening in the background that's not obvious to the claimants you're interacting with. They can feel like, you can have a very natural narrative. They will feel like they are dealing with someone personally, even though they're not. And then by using that automation piece, you're actually implementing in these mass claim environments, consistency and audit trail and all these other things that you need to have underpinning those sort of processes. In addition to that, I think it's key for us as a business to always keep an eye on how other changes in other tech are going to impact on the way we've been doing things. So as many of you listening in may well know, Google have announced that they will be phasing out third-party cookies on Chrome by the end of this year. So certainly for us, if we look at what's on our roadmap for this year, we are already looking at how we can communicate with and find claimants in the context of book building, which is where third-party cookies get used a great deal, by using first or second party data rather than the third party data. And that's something that we have the wheels in motion to make sure that we're deploying tools that enable us to do that. But I think that's a very significant consideration for all of those that are involved in any book build style activities, especially if you're using third-party lead generators where actually it's their data, so therefore it is third-party data that you're relying on, etc. So yeah, two things on our roadmap this year, and I hope that they're not overly ambitious, but implementation of AI and accommodating the phasing out of third-party cookies, because Google have announced it. I'm in no doubt that other tech providers will follow suit.
I mean, they're already following suit, aren't they? Because
Yeah.
we know that Apple and others are looking at this in three ways. It's not just on the website or the browser, it's actually also device. So the privacy directive, like many legislation, takes a little bit of time to come in, but it's interesting that really kind of the leading players in this space are already making decisions and stepping forward in terms of how they further protect customers from data and privacy. So being ahead of the game on that one's really interesting. And I love the piece about AI, not just because it's the buzzword of the moment, and everybody wants to talk about it, but I think if we frame it back in what we're talking about here in terms of that unprecedented scale, when we talk about verification, and anybody in the legal sector will know what verification looks like. You're all doing it as part of book building and managing these cohorts of claimants. There's always a bounce, there's a referral, somebody doesn't pass, and largely in the domestic individuals space, it's small, it's 0.01%. But as soon as you've got anything that has an international nature, anything that is including businesses or corporates, or as Andrew said, institutions, it brings with it some complexity, and actually your referral rates are likely going to go up. And if you're talking about a few thousand or a few hundred or whatever it is people, it's manageable. But then when you start looking at the size of the claims that we're staring at, excitedly and scaredly, when you're talking about those sorts of percentages on top of millions in terms of claimant cohorts, that requires a whole approach in itself. You've potentially got hundreds of thousands of people who are falling out of a process, and that's serious size, and that requires a lot of thought. Actually, can AI be something that helps you to look at that, cohort of people who are going to fall out of a process and see, well, what can we automate and how can we streamline this so it's not suddenly all manual intervention? That's certainly where ShieldPay are experimenting and bringing AI into our process. But I think, in the sense of this talk, that's perhaps a practical example of just realizing where automation can really come into its own.
And just to piggyback on that, sorry, I'm jumping in now, but to utilizing the existing tech solutions in this space. So open source banking, I know that's something that you guys use at ShieldPay, but that's already technology that a huge claimant community will be familiar with, and it'll form part of the way they live their everyday lives. It's how they manage their finances. So being able to tap into that technology to overcome verification challenges in an automated fashion, which means you don't have to manually there's no manual intervention in the event that someone initially fails verification. Again, I think that's powerful as well.
I'll give a little nod to some of the shield payers who have logged in and are listening in. Massive kudos. We started a settlement on Thursday lunchtime last week, and by the end of the day, Friday, we'd paid about 80% of people. So that's going from verification all the way through to getting money into the hands of claimants in 36 hours. So yeah, the power of open banking is pretty special. Right, no more from ShieldPay. Over to you guys. Andrew, I'm going to come to you. So with a view on, and we talked about this a little bit earlier, but with a view on the judiciary and larger securities cases, leveraging different procedural rules in terms of collective redress, can we benefit further from looking at the CAT and seeing if we can bring any of that into scaling operations for commercial litigation, and things like, can the concept of umbrella proceedings be adopted in the commercial space for securities?
Well, yes. I think the short answer is yes, and it should. I mean, just to back up slightly in terms of practical steps that Fox Williams are taking, to gear ourselves up for the increased scale of these cases and volume of them, and just in very practical terms, as well as the tech solution that we're looking for, we're going to implement this year. We've scaled up our team. We now have 2 dedicated partners, 2 dedicated senior associates, and a cohort of junior associates who are focused on securities litigation cases, almost exclusively. So, we're kind of building up the team to be able to do it as well. And I think we're trying to look at these cases as a portfolio, and in terms of, again, practical but perhaps behind the scenes steps that we're taking, in terms of the financing and the insurance of our cases. We feel like we've now reached the point in our development that we're not just talking about one case at a time. We're talking about potentially a suite or a portfolio of cases, so that we can hopefully, we can get a finance package or a portfolio in place with a funder and an insurer that can, minimize the cost, and therefore we can pass on better pricing to the claimants. So I think that the whole industry is going through a sort of maturity phase as these cases develop, and we all get used to them and adapt our processes and scale up, as you say. From the judicial legal side of things, I guess the point is, yes. I mean, there are, again, first and foremost, as an Australian practicing in London, I had experience. I grew up with the Australian class action system, so it exists, and it's not just sectoral. In England, for reasons I don't understand, there was this sort of test ground approach. Let's have a regime, but just for competition cases or antitrust. But I don't really see any reason why it shouldn't apply across the board, as it does in Canada, the US, Australia, many other jurisdictions. So that's a bit of an oddity to start with outside the CAT and the competition space, but certainly sitting outside, we do watch the CAT and how the court is handling the rise of these cases, and we're looking for best practice examples that we can try to bring across into the financial list or the commercial court, where our cases tend to be. From an access to justice point of view, and from I guess a strategic point of view, we think 19.8, CPR 19.8, the representative claimant mechanism. I mean, I think I've long thought that was appropriate for shareholder cases, because if you really break those cases down to their basics, they're almost like product liability cases. The shares, the stocks of that public company have been impacted, have been damaged by whatever the wrongdoing was, allegedly, that the public company hadn't told the market about. So whether I've bought 1 million shares or Claire's bought 10 million shares, we're still buying the same product effectively, or the same thing that's damaged. So I've always thought securities cases are well suited to the same interest test under 19.8, and that one representative claimant ought to be able to represent the group of shareholders. And I think that hopefully that will have, that it's at least one solution for that gap in the market that I talked about earlier, where retail investors don't seem to be getting a look in the shareholder space at the moment, or on any large scale. So, I look at the CAT cases. I also look at what the court is doing in the NOx cases as well, the emissions cases. It looks, I think, really positive that the court, whether or not it should have happened earlier, but it's at least now taking a much more hands-on approach, it seems to me, in dealing with multi-party actions against the same defendants, or against the same sort of suite of defendants, like diesel manufacturers, for instance, or the credit card providers in MasterCard and Visa. So, yeah, I'm hoping we can kind of drag those good practices across into the commercial court, or the courts can themselves see that there are solutions that are being deployed in some areas that can be carried across. I think, unfortunately, 19.8 has been tested only once so far in the shareholder space. There was a strikeout application in securities litigation against Reckitt and Indivior back in November, and the judgment came out in January, I think, and the judge ruled in favour of the defendant, so struck out the use of 19.8. I sat through that hearing and I read the judgment very closely. I think it's really, I don't understand it. The judge seemed very concerned about 19.8 seeming to limit his case management powers, and it's, I mean, my personal opinion, that was just overblown. It wasn't. It didn't need to have that interpretation, and every case in every court is shaped by what the claimant chooses to claim and what the defendant chooses to defend, and the judge manages the issues that are in front of him or her every day. So it seems strange that that interpretation, but permission to appeal has been sought in that case, and we're waiting to see where that goes. And I think in other cases outside the security space, 19.8 has received a much more welcome reception, effectively, or had more welcome reception in the Commission Recovery case. The Court of Appeal, also in January, rules in favour of 19.8. So I'm hoping the direction of travel is more favourable to 19.8, because I think without having a class action regime, whether it's opt-in or opt-out, that is agnostic, across the board for all cases, then we need to just do what we can with what we have, and the rules that are in play. And I think since the Supreme Court's decision in Lloyd and Google a couple of years ago, 19.8, I saw that as a roadmap for how 19.8 should be able to be used, and we're trying to do that in 2 of our cases, and we'll see what happens with them this year. But if it's not 19.8, we'll find other ways to try to run these cases in the most effective and efficient way. And there are lots of other things we can talk about, like split trials and GLOs and other mechanisms that can be employed. But I think 19.8 should work if we can convince the right people.
And it only takes one.
Yeah, it's a shame that the first one got knocked back, but hopefully we'll keep plugging away and we'll get the right results eventually. But yeah, I think whether it's that mechanism or others, the key is, for us, as we've all been saying, we're trying to figure out ways to be able to bring these cases in the most efficient way possible, which also means the most efficient for the court and the use of the court's time and the limited resources of the courts and the judges. I think England is doing a pretty good job on that front and is ahead of, for instance, some of the continental European jurisdictions, but they are rapidly catching up because they have the collective redress directive that they all now need to implement and adhere to. So, if we want London to remain a hub for international litigation and large-scale commercial litigation, we have to find a solution that works. And they're sitting there. We just need to be able to grab them and use them, I think.
They absolutely are. I always think about this in terms of when new technology comes out. My husband would always be the beta tester because he loves it. I'll just sit back and see and watch how it goes. So maybe let's get something through the cat and then think about how we leverage it for other areas of litigation. I know we're all waiting with bated breath for decisions ahead of the summer recess. So Rosie.
I do, just to jump in, sorry, I keep jumping in, but I do share Andrew's slight concern that before we know it, we won't be as innovative as we are. We'll have lost that, forward-thinking, trailblazing position that we have benefited from in the collective, the European collective redress landscape, if you like. So, another thing you were saying, Andrew, which really resonated with me is about, dealing with it efficiently. And that's not just us dealing with them all efficiently, but the judiciary being able to deal with them efficiently as well. Because let's face it, we all know, I mean, Rosie more than anyone probably, because she sees all the proposals, but there's no shortage of these claims in the pipeline. The quicker we can get efficient processes for handling them and getting them through our system, the more of these cases that can be resolved, right? And the less that will have to not be picked up because, they're seen as too challenging because there isn't a way to bring them collectively and it's not viable commercially to bring them in a non-collective basis.
I mean, perfect segue. Thanks, Claire. You can host it.
Sorry,
actually, not at all. Because actually, what I was going to ask you, Rosie, is, whilst it is still a maturing concept within the broader investment market, it is getting growth year on year. And so what is the big priority? As Claire said, there's no shortage of cases. How are we going to get on top of all of that? And what are the big priorities for litigation funders this year?
Yeah, certainly, Claire, a number of priorities, certainly. The first of which is is concentration risk, which I've already touched on, so won't mention again. But perhaps most prudently at the front of all of our minds is the pursuit of clarity on the reasonableness of funding terms, especially in the context of the larger budgetary requests that we're seeing. And I'm talking obviously in CAT specifically at this point. So the CAT has, outside of determining PACAR-related issues, it shied away from providing much guidance or clarity on what it might perceive as reasonable in respect of funders' terms. And I mean, we've seen defendants use PACAR as a way into that and to try and make submissions about how funding terms are excessive or likely to risk a conflict between the funder and the class reps and ultimately the class. And I mean, good news, the tribunal's not really been drawn by these arguments, and it's been very, very clear that its role ahead of any settlement or judgment is to provide close supervision of costs to ensure that they're proportionate and to ensure that the PCI is sufficiently independent from the funder and acting in the best interests of the class. I mean, recently we've had a number of helpful judgments in the CAT and the Sony Meta, and very recently the Goodman Apple funding judgment, which was handed down in March. In these judgments, the tribunal again has emphasised proportionality of the funder's return by reference to the risk, level of funding commitment, complexity, length of proceedings, and commented that any concerns about the funding terms are best dealt with in the context of any judgment or settlements once those indicators are known. In the Meta case, the CAT did indicate that the funder's multiple was too high, with the result being that the multiples were reduced ahead of the hearing on funding, which resulted in the tribunal then being comfortable in certifying the proceedings, but noting that they were not in any way approving or endorsing or expressing any kind of approval of the terms on which these proceedings are funded. And in the Goodman and Apple funding judgment in March, the tribunal endorsed the comments in Meta. In that claim, the funder is entitled to a 3.8x multiple on committed capital in addition to repayment of its drawn capital. And the tribunal concluded that whilst this was a large sum, they didn't think it was sufficiently extreme to warrant calling it out. So whilst the indicators are certainly positive, I think us funders are still quite in the dark as to how the tribunal might approach the funding terms in the context of a settlement or judgment. So that, obviously, for obvious reasons, we're very, very interested to see how that plays out. And the final issue, which, I mean, Andrew touched on this already, and Claire, you have too in your preliminary comments, but duration risk continues to be an issue for funders, and that is something which obviously doesn't naturally lend itself to collective proceedings of any manner. Obviously, you don't invest in a group claim thinking you're going to get a return within a 2-year period. Unfortunately, that's not the world in which we exist. That said, the length of time that both the CAT and the High Court have been taking to administer collective or group actions has been, to put it politely, elongated. But what we have started to see, though, is the High Court taking a proactive approach to the managing group claims. And Andrew, Claire, you both mentioned the PANNOX case management decision. This is, it's so important for us. It's great news for all stakeholders on the claimant side that the court has taken this approach. And I think we're all just very hopeful that it will work out. And certainly the CAT also seems to be getting itself into position to move cases through at a better speed. So whilst it does remain, it remains to be seen how successful case management, certainly in the High Court, will be if large cases can be streamlined. It's good news for all of us, the court, the funder, the administrators, the law firms, and ultimately the claimants themselves.
I love that example about PANNOX, because I'm a big believer in that if you just inch forward and grow a little bit and this, that, and the other, you constantly take bad practices with you. And it's not until you actually go, let's aim for the stars, let's do something really big, it'll challenge everything that we know today and everything that we, every way we work. I wonder if we'd have sort of drip fed some of the manufacturers in the next wave of emissions, whether it would have changed, but actually 14 of them all coming at the High Court together in one go actually forced them to say there's a better, more proactive way that we can deal with these cases so they're not in the courts for the next 5-10 years, whatever it was going to be. And so, as much as change and this, what we're talking about today can be a bit scary, I also think it's really powerful in shaking us into new ways of thinking. And we couldn't get through a talk without talking about Packer. I hope Susan's on the call because it will become a footnote at some point. But it's an interesting kind of play, isn't it, when you've got the delays in the understanding of the structure of funding in these cases, and then the duration risk. One's feeding the other at the moment. So Andrew, definitely wait in the wings and see what happens, and we'll iron out all the challenges and then make a play for bringing this into the commercial space.
Well,
Okay, go on.
sorry, no, just to jump in, Claire, on that point. I mean, I should say, in terms of how these cases are being developed and handled, in the commercial court, they're probably the biggest one that's going through at the moment. I think I'm aware of. There are 5 law firms bringing claims on behalf of clients against Glencore, and which arise out of its admissions, its deferred prosecution agreement, and its other statements in relation to bribery and corruption. And 4 of those actions are going before the court for a CMC next month. So not ours. We're bringing ours as a 19.8 action, as I touched on before. I don't see any reason why our case shouldn't be case managed with the others. For our group, I think 19.8 makes sense. Doesn't mean that for the other groups it has to make sense for them. Some of the other firms only have 1 client or a handful of clients. Some of them have hundreds. We have hundreds. So we've chosen 19.8 as what we think is the appropriate way to manage our group. But we think that our group can sit alongside the others. But obviously the defendant is taking a different view, and they've issued a strikeout application against our claim. So it's sort of slightly being run on a different track. But the other 4 firms' cases will be in front of the court next month, and they are currently subject to a joint case management order or consent order. They've agreed to do that. They've collaborated on a common particulars of claim, and then a common reply to Glencore's defence. So the firms are working with each other to bring the claim in the most efficient way possible. And I think that's one of the interesting dynamics of not having a class action regime for securities, where it's opt-in. That does mean that it's competitive in the book building stage. So, as I said, we're building 2 cases at the moment, and we know other firms are trying to go after the same clients. So it's competitive now. But fingers crossed, if we manage to get a group together which is commercially viable, as we did for our group against Glencore, it doesn't worry me if other firms have got their own clients and their own groups, because we work together. Once the cases are launched, there's no need for competition between the law firms. So we don't face this sort of carriage dispute risk that does occur in the competition space. But we do have the challenge of then, 3, 4, 5 law firms trying to work together in the most efficient way possible. But it can be done, and it has been done in the past. So I think, again, it's sort of watch this space in the next few months in the commercial court. Hopefully we'll get some good decisions coming out of these interlocutory hearings.
And maybe there's some kind of broader elements that we can also look to, that the collective and competition space have been brilliant at pioneering things like Caller, bringing together the firms that are working in this space to do what you've said, to work together on the bringing of cases, and to learn and lift the industry up and move it forward.
Yes.
And actually, just to add to that, I think that we've seen some real practical examples of that. If you look at what's happened in the Mercedes emissions space, in that this collaboration between claimant firms and a steering committee has enabled those that are representing claimants to do their own proactive deduplication and various other protocols that historically would actually be things that would end up undermining the integrity of claims, and things that defendants could jump on quite easily. But I think that the claimant community, when cases are being case managed together and they're working together, that enables the claim as a whole to be presented in a far stronger, more robust manner to the defendants, and a very a very concise as well as consistent manner as well. So I think that helps, helps the regime as a whole. I think it makes it easier for the defendants actually, ultimately, and also it's less spend for the funders. So Rosie, there's not lots of interlocutory applications about which argument is the right one, or how the data should be presented, or what we're going to do with all of these duplicate claims that are being presented to us by multiple different firms, because that's all being dealt with very proactively and case managed by the judiciary, to strip away some of the things that have been sort of time, resource and money drainers historically in group litigation.
Love that. Some of the whole is always greater than the parts, right? Okay, we have 9 minutes. I knew we would do this because we just had so many things to cover. Final kind of question then is looking more towards the future. So horizon scanning, road mapping for us techie folks, but what are we seeing that's coming up that we also need to bear in mind as we're thinking about scale? Claire, one of my biggest fears, it's like the commentator's curse type thing, but it's the fear of handling data breach cases and then somebody in the chain having a data breach themselves. It's one of those things I wake up in the middle of the night in sweats. But how are we making sure that our practices are leading the way in advancing security, especially when we're handling data for millions of claimants?
I share those concerns as well, Claire. You're not alone. But yeah, I mean, the irony here is, right, you're handling cases that relate to use of data, and then you have a problem with your own use of data. And that is a real concern. And we are living amongst the big data times. And when we're looking at these collective proceedings where there are millions and millions of claimants involved, that generates lots and lots of data, especially when we're constantly advocating the use of technology and digital tools, and taking in, moving away from manual and paper-based protocols. All of that is just creating more and more ESI, like electronically stored information. Currently, we are the claims administrator for Lisa Gormson in her claim against Facebook. That's all about how Facebook used, the data they were given by their users. And then just today, we've seen the announcement of the claim against Grindr, which is about how that particular platform was sharing data that was being collected from those that were registered. So it's a real hot topic. I mean, there's the obvious stuff, right? So, making sure you're always acutely aware of your obligations, whether you're acting as a processor or whether you're acting as a controller, ensuring that all of your team have very regular, refresher training on spotting cyber risks. The thing is, the cyber criminals become ever more prevalent and ever more sophisticated. So as soon as you think there's a tool out there that stops this particular threat or risk, they will be ahead of the game and developing something else that will overcome that. I think the main thing, if we look at these mega settlements, the main thing that's going to be a hot topic is fraud prevention. It has to be. That is overcome by the deployment of good fraud prevention software. It will do a multitude of things, these software, these tools, but it will identify people that are coming into your system but don't appear to be humans. There's activity there that suggests they're bots. There are systems that will stop a claim before it even comes into your system, so because it thinks it is highly fraudulent or it's a phishing attack. So it will act like your firewall does or your spam filter does on your emails. And then the other tools like IP monitoring, so you can see whether there's a vast amount of claims coming from the same IP address. That would be very unusual characteristics, unusual activity. And make sure that you're using, I go all the full circle, but make sure you're using robust processes and systems, and you're working with partners who have their eye on this, that make this part of their core business, right? So we have to make sure that everything we do is SRA compliant, is GDPR compliant, is compliant with our obligations to the ICO. And then we will only partner with people who are maintaining similar standards. And when you talk about distribution, we then have to worry about what the FCA have to say about what's going on, etc. So you only partner with people and only use tools and technologies that are FCA compliant as well.
Absolutely. It's if I could boil it all down into practical terms, please stop emailing spreadsheets of personal data.
Or copying
or
spreadsheets, or exporting data out and just saving it on random networks. Yes.
I know. Brilliant. Thank you. Rosie, litigation funding, whilst we're talking about the FCA and regulators, is currently a self-regulated sector, permitted under statute, case law and public policy, but not yet governed by regulation. What are your views on the subject of increased guidance in this space?
I think regulation is in danger of becoming the next PACCAR buzzword, which is, but no, Claire, it's a very, very topical question. Last week, there was a second reading of the Litigation Funding Enforceability Act in the House of Lords, and Lord Stewart reaffirmed the government's position to have the Civil Justice Council undertake a wider review of the sector. They're going to look at a range of issues, one of which is regulation. So an interim report is due to be completed this summer, a final report due next summer. So obviously we're all a little in the dark until the publishing, I think, of the interim report, certainly. But I understand that they will be publishing terms of reference for the review shortly, which will provide some more colour. I think that's actually expected, any day. I read the transcript of the discussion in the Lords last Monday. I'm sure some listening will have done as well. And what is clear from that is that there is a vast divergence of opinion of litigation funding, and I would also say of understanding of the industry. So for actually my view that a closer look at the industry will be to our benefit, in that will illustrate how far we really are from the exploitative industry that some are seeking to paint us as. And as many of you know, the majority of us are members of ALF and or ILFA, which means we have a code of conduct that we adhere to, and affirm levels of capital adequacy and other professional standards. And whilst yes, it's self-regulation, we as an industry obviously have an aligned interest in ensuring that high professional standards across the market are maintained. And as you mentioned, Claire, the majority of us were also FCA regulated, so we already adhere to a high level of regulation. But that being said, I don't think the majority of us are shying away from the idea of regulation. But there are obviously concerns as to what it may cover, and that should become more clear this week, I guess. But the main concern at the moment amongst funders is this idea of a cap on funder profit, which certainly in my view would be a mistake. I mean, as many will know, the investments we make are on the whole non-recourse, meaning that we, on behalf of our investors, take on a lot of risk, and there clearly needs to be financial reward to offset that risk. And if such a cap were to be introduced, I mean, I don't know if it would be on a case-by-case basis or I just don't know how it would actually work, but it would greatly harm access to justice, as funders, I think, would just be heavily restricted as to which cases they'd be commercially able to back. And then that would just, for the litigation market as a whole, I think that would be a real shame, because funders will just take their money elsewhere, and then claimants won't have access to justice, and yes, it would just be a real shame if that's how it did end up.
And it's interesting because the litigation funding space, as you say, FCA regulated, but also looks and feels much like many other asset classes that are out there. If we're not capping those, why should we cap litigation funding? So
yeah, and I think there's also law firms are involved as well. I think law firms are advising their claimants on the terms as well. We are always in competition, or generally in competition, with other funders when we're offering terms for a deal. So this idea that it's exploitative, it just isn't, because you've got to have competitive pricing to be the preferred funder in many options. So I think, as I said, I think a closer look at the industry will be beneficial.
Fantastic, thank you. I'm conscious of time in our last minute. I've given you a really thorny topic, Andrew, to try and cover in a minute, but maybe we'll run on a few more minutes and people can watch back the recording. So the SRA, to talk more about regulation, has recently announced a thematic review of client money. In the wake of growing incidents, I'm sure we've all read about Axiomints and others. What impact might this have on law firms in terms of growing regulatory pressures, but also potential changes to holding client funds and processing transactions in-house?
I mean, I'll keep it short and sweet, given the time. Looking at it from a positive point of view, which is what I always try to do. I think for well-run firms like Fox Williams that take AML and client onboarding and the client account and our regulations around the client account seriously, then I don't think the review should cause anyone any concern. And maybe it's a positive if increased regulation or increased focus from the SRA might keep a few cowboys out of the market, then that's probably a good thing. But I think, beyond that, I think there does need to be some, and I think actually there are already some solutions. There is a concept of a third-party managed account, which exists under the rules at the moment. So we as law firms don't have to hold settlement sums or judgment amounts, which can be enormous sums of money in our client account. They can be held separately, and businesses like yours, Claire, can then distribute them. And I can vouch for the fact that trying to do it in-house, even for a much smaller group and for institutional investors, on one of our recent cases, it took us 2 years to distribute the funds. And I'm slightly embarrassed to say that because that's a long time, but it wasn't for want of trying from our point of view. We had many funds sent out, bouncing back 4 or 5 times because it wasn't quite right, or it wasn't noticed by the institutional investor when the funds hit their account. Because millions of pounds for us seems like a lot of money, but if you're a massive bank, that's actually just a blip. We need to have better solutions, and the point is there are solutions. And I think as long as there are controls and regulations around how they're dealt with, because ultimately it's clients' money, it's other people's money. We have to take it seriously and protect it and make sure it gets into the right hands at the end of the day.
Absolutely. I'm so sorry we left you with like no minutes left at the end. But for anybody interested in this topic, we are actually working with Thought Leaders 4 to bring together a round table where we can have a thorough discussion on all things client money. A huge thank you to Claire, to Rosie, and to Andrew for today. Really appreciate your time and fantastic insights and thoughts. And thank you to everybody who joined. If there's any questions after we've finished the webinar, just pop them across to us. We'll be happy to answer them. And thank you to Thought Leaders 4.